Elected.
Yeah.
Hold on, we may.
You're live.
So beautiful. Can I have a from your clothes? Because I take this.
Okay, we are going to go ahead and get started. Welcome to the Law and Licensing Committee. We are here with all 5 of our committee members present. Member Lear, Member Wood, Vice Chair Carey, and Member Hart, and myself, Matt Hymas. So we will go ahead and get started this morning. We have 2 public commenters. We have one public commenter has a comment on 2 rules, and so we're going to allow him, instead of putting it all on the table now, we'll hear from them as the rule or before the rule approaches. So we'll first hear from Sarah Jones from the UEA, and we'll take, of course, keep it professional and clean. No problems there. Okay. And yeah, if you want to take a few minutes, that would be great. Thank you.
Thank you. Hey, good morning, board members. I'm Dr. Sarah Jones with the Utah Education Association. My comments are actually pretty brief and very clean. On Rule 123, I just wanted to point out one particular section that I think leads into the broader concern that's been already raised about more work needing to be done on the rule. And I'm going to address lines 48 to 54, which create the definition of other concern. So the rule lays out the alleged violation, which is statute and board rule, and then other concern, which is intended to direct like what would be happening at the LEA level. And I think the definition here is just really broad and probably not getting quite to what you want to do with LEA, potential LEA complaints. So first of all, on line 51, it uses the term alleged violations, which alleged violations is defined in another way previously in the rules. So I think that would be something to look at and just to drop alleged. But more broadly, lines 53 and 54. So it says that another concern that would be addressed through a hotline complaint is other issues such as employment and human resources actions. And I think this is incredibly broad, probably broader than is going to be helpful. So, for example, employment issues could be everything. And let me just say, it's not saying misconduct. It's not saying educator misconduct, which would be very appropriate, right? It's just saying other issues such as employment and human resources actions. So employment could be, why did you hire that football coach? Right? Employment could be a performance evaluation question, a compensation question. It could be a complaint about what discipline or remediation might be happening with a particular educator. And those are things that are confidential matters. And so I think this section about what you really want LEAs to be addressing as community or parent or student complaints come in just needs to be tightened up and focused. And that's it. So thank you very much. I think the rule just needs more work than is ready to go forward today.
Thank you.
Thanks.
Next, we have Royce Van Tassel.
Good morning, Royce Van Tassel, Utah Association of Public Charter Schools. I will also say, though, that some of my comments will reflect the various times I've served on the board of a couple of different charter schools. The 123 says that we want you, LEA, to have a separate hotline process to consider various concerns that have come up. And the word other concerns, as we heard from in the last comment, is remarkably broad. I will say that in my time both at UAPCS and serving on various charter schools, what I have often seen is someone has brought this concern to the board or to the administration of a school. They didn't like the outcome that they got, and so they go and find somebody to agree with them. And I know that because at times they come to me in my role at UAPCS and say, hey, someone did something and I went and appealed and didn't get the outcome that I wanted. Can you, UAPCS, fix it? And of course, the answer to that is no. We tell them that's something that you should address with your charter school. But this is saying you have taken that to the school and you had the conversation with the director, and you may have had the conversation with the board and you're unhappy with it, but now you're giving them an opportunity to send it back to them to redo the evaluation that they had in the first place. And that feels like it is not going to result in them feeling happy about this outcome, because they have to take it to them even before it would go potentially to the state board. So I think that there is some duplicative work here going on that isn't necessary. I will say I had a lengthy conversation with Debbie Davis on Tuesday and went through a number of pieces of the draft that in one case, and I can give you all of the specifics, but I doubt that's necessary in this forum, where one section says they may do this, and the immediate following paragraph says they shall do it. And it's got to be either one or the other. It's really hard to say you may review this and then you shall review it. One of the two has to be the case. Right. Exactly. So I understand sort of the direction that this is going, but I think that there is a lot more work that needs to, before this moves forward to the full board. I would encourage you to take the feedback that you have received from my colleagues, both on the district side, the charter side, from what the UEA has said, and let's see if we can, over the next couple of months, come up with something that's a little bit more workable. Thanks.
Thank you, Royce. With that public comment being finished, I don't believe we had any others. Let's go ahead and jump to agenda item 1.2. This is R277-123, process for members of the public to report violations of statute and board rule. And we have Ben Rasmussen to kick us off.
Thank you, Chair. Ben Rasmussen, Director of Law and Professional Practices. Good to be with the committee this morning. R277-123 has been prepared by our internal audit team in consultation with the audit committee. What I can do is I can just kind of walk you through what the primary changes are, and then and if it's appropriate, we can invite Chief Audit Executive Davis to kind of talk about the reasoning and start to answer any questions you have about this. But this has essentially been a major rewrite of this rule. You'll see that new statutes have been added to the authority and purpose. We've added the oversight category on lines 22 through 25. This is a category 2 for the LEA portion of the rule, and then it's exempt as to the piece that deals with the board hotline, because board staff is not an oversight entity, so we don't fall under the oversight framework. But essentially, what the audit team has attempted to do is to clarify and kind of rewrite the procedures for how the board hotline is conducted, explain how they will review those hotlines, refer them out, handle resubmitted hotline complaints. And they've also are recommending that a piece that was in 113, and we'll be looking at that rule later on in the agenda, but the piece in 113 that requires LEAs to have their own hotlines or rely on the board hotline, they're recommending that they're kind of moving that to this section and adding a section about an LEA hotline and responsibilities about it. This does change that so that LEAs would be required to have a hotline under this draft, and then it kind of prescribes the procedures that would be around that. So we've rewritten pretty much every section except for the last one, which deals with the board's appeals of sensitive or library materials, I believe. But everything else has been significantly rewritten. And so we want to invite CAE Davis. She can kind of give you some more background as to why they're recommending the changes. That's okay.
Thank you. CAE Davis.
Okay, Chief Audit Executive Debbie Davis for the State Board of Education. There are several reasons why we brought this rule forward. And first and foremost, I'll say the board is committed to local control, and that's what the clarifications, the reorganization, the reformatting of this rule attempts to make sure that that is preeminent, that local control remains. There are a lot of different options and ways that concerns from stakeholders, parents of education could be handled, and we felt this option prioritized local control. A couple of reasons why. There in R277613, there's already a requirement for LEAs to have an individual designated to handle concerns related to bullying, which happens to be one of the top concerns that we get. So there's already an individual, there's an existing process there. And we're very aware that LEAs are handling concerns and other things with parents all the time. We're aware several presentations to the legislature have been made recently by LEAs about how they're working with parents, which is wonderful and awesome. And even the public comment from the PTA yesterday was about the importance of working with families and parents. So we know everyone is committed to at the local level, and we have our Where Should I Start document, and it always points to start at the most local level. So there was never an intent that the State Board of Education was going to investigate every concern that came in. And I guess I'll mention as well the requirement for some mechanism, and 123 makes that the public education hotline to receive concerns is required in Utah code. So we have to do something, but that something is not, again, that we're going to do the investigation. Frankly, we don't have the resources to do that given the volume of concerns coming in. So we are receiving concerns. That's the role of the hotline. We receive concerns, we understand risk, we might have an initial conversation with someone, and then we refer it back to the LEA to handle as they see fit. And nothing in the rewrite of 123 is saying that you have to handle it in a certain way. It's saying have a policy, do it consistently. That would mitigate your liability. It would be a more efficient process for everyone involved. Everyone would know who do I go to if I have a concern, which is really important. There's a lot of frustration if you have to jump from person to person to person. So we thought that clarification would be important. We've also heard from individuals who contact the hotline, and even from at least one LEA as we've sent concerns, and they looked at 123, and they were interpreting pieces of the rule differently. And so we thought, well, if there's different interpretations about what should be happening here, maybe the board should look at that, and there's some clarity that we could provide to mitigate confusion, so that there wouldn't be a problem there. Again, going back to local control, there is the provision about, hey, let your audit committee know what's going on. Utah code for, I don't even know how many years and years, has required every LEA to have an audit committee. And it's to help with governance in the areas of, there's all the audits out there, there's monitoring, there's risks with hotlines. And so use something that's existing, right? Just like you're already working with parents, that's existing. 613, you have someone designated for those concerns. You already have an audit committee. Is it one more report? It is, but I will say the level of concerns, at least that we're seeing on the hotline, if you look at an average per LEA with the concerns that we get on the receiving side, we average 5.7. Over the last 3 years, we've averaged 5.7 concerns per LEA. Now that's an average, so some LEAs would have more and some have none that we receive. So we think for the majority of LEAs, this would be very minor report to the LEA's audit committee. But again, prioritizing local control, have the local board be aware of what's going on so that they can govern and make policy as best as possible, right? It's important to know what's going on. And I know I have received a lot of questions about the hotline. We report to the audit committee on a monthly basis about the hotline because we feel that it's important. So those are some of the reasons why the edits came forward the way that they have. We believe this is a starting process and that absolutely multiple viewpoints should be considered. And of course, ultimately, this is a board rule. So the board will make a determination about how this should go forward. But our feeling is it's not a significant change to it should tap into existing policies, procedures, processes that are already in place at LEAs. It taps into local control and commitment to parents, and it just clarifies. And Ben already talked about, we're putting the oversight category in, and then there's additional legislation. The legislature is very interested in what's happening on the public education hotline and refers to it more and more. So we're seeing that as well. And so we wanted to make sure that was clarified. So Chair, I hope that was an appropriate explanation.
Thank you. Member Wood?
Yeah, I would just like to motion that we refer it back to staff, maybe for November, December. I think there's I could wordsmith to death today, the shells and the maze. There's a couple of paragraphs that I'm concerned about, but I think if we just looked at it holistically, we also got emailed 5 minutes before from some legal counsel that have brought forward some concerns. I think if we just take some time to look at it and maybe consolidate. I'm not opposed to where it's going, but I would like to see us work on it. So I would move that we refer it back to staff and bring it back at a later time.
Okay, so the motion, let's make sure we get it correct up here. And I appreciate the motion. At the same time, I appreciate the process here so that we can make a motion and get this started. What's interesting to me was, there'd been some discussion, and then this rule came out. Now there's lots of discussion. So good things are happening. In my opinion, we're seeing this and we're saying, a lot of people are saying this isn't what we're thinking. We're getting some things from staff. We're getting some things from constituents, from board members. So I appreciate the feedback. I appreciate the motion. I don't think it's ready to go through today either, if I speak to your motion. And I don't think it'd be ready to go, even if we said, well, let's pass it and go to the boards, as sometimes we do. I don't think it'd be ready in November either, quite frankly. So anyway, speaking to that motion.
Go ahead.
Okay, I've got Member Hart in the queue here, but go ahead if you.
Just wanted to add a perspective from program staff, because of course you've got Ben, policy team, you've got Debbie Davis, who's with audit, but we actually, as superintendency with the assistant superintendents, have also discussed this not this specific rule and language, but in general, the concept that Debbie has just stated, really the recommendations are in the space of local control. I think sometimes when people look at this rule, they think it's the board trying to be the overseer and actually have more come to the board, and it's actually the opposite, because program staff, as you know, with the process, and when I say program staff, I'm talking about people like in student services like SPED, or UPAC is another one, but even teaching and learning, that as the complaints come to USBE, if they come for the first time through the hotline, they haven't gone to a school or a district first, which happens when an LEA does post our hotline as their hotline. What has those referrals will go to the LEA, but they also go to USBE staff. And oftentimes families have been very frustrated because they think that they're calling USBE and that we're going to make class changes, like move the bullying, move the 2 students from a class to another class, and we have to share with them that that's actually a local, district or charter school responsibility, and they get very angry. And so I just wanted you to know that part of it's feeling like at times when families don't go to their school or district first and they come to USBE first, and we tell them you need to go to your school or district first, it just creates extreme frustration. And that is part of the reason why I think you'll see this recommendation for LEAs to look at it first, or to have their own hotline or their own audit committee, because ultimately, if the work is done at that local level, then I think parents tend to be less frustrated. They get quicker responses. Most times the issues are really at the classroom or the school level. And so just wanted to add the program staff perspective in addition to audit and policy. And again, these were just things I've heard. We've actually had some staff be the recipients of very belligerent parents to the point it's almost been a morale issue for staff where they share, I'm sorry, we do not have the power to do what you're asking, and the people don't believe that, and it ends up being difficult if they don't go to the locals first. That's it.
Thank you. So I think, and Member Hart, I'm sorry, I appreciate the fact when somebody comes to me as a school leader that can help them out. So I do think that there's a balance in here somewhere, right? Yeah. So anyway, thank you. Member Hart.
Agreed. I had an opportunity to talk with a superintendent recently who was upset that a constituent had called the hotline, and the sentiment was that belongs in my district. That's something I should handle, and I explained the procedure as best I could and apologized, for any misunderstanding, and it was fine. But the simple fact that they really felt like they owned that, they needed to own that issue and wanted to deal with it, kind of struck a little bit of a nerve for the same reason. I've been on the receiving end of constituents calling because they didn't like an answer or a decision I personally had made in my day job, and it's a process. I get it. I understand. But it is something that we need to think about, practicing what we preach, kind of thing. The other thing is, I think people also assumed that this meant, and this goes to clarifying the rule, that this means you have to hire a person and they have to sit by this hotline. And no, we also have a fraud, waste, and abuse hotline that every district has to have. In some of these, especially larger districts where there's so many layers to as a parent, you don't know how to get to the person. So to have one number on a website where the person that's answering the phone knows where to send it is not an unrealistic expectation. Now, as for the rule not being ready, yeah, that's a problem, that's a conundrum we have in audit. If audit is a different kind of committee, by necessity, much of the work is the meetings are not subject to open meetings, and there's justification for that. But when you get to things like a rule, do you leave it in audit where there is not the sunshine of public, or do you get it immediately out to a committee that can hear, concerns and dialogue? The problem is that if you're not really clear on that you're not looking to immediately go and take it to the full board or whatever, that you just want to get it into the sunshine so that people can have conversation and we can hear public comment. If this rule sat in audit, these conversations wouldn't have occurred. So in some ways, we need to think about our processes, because bringing something forward means that we can be more transparent. So while I very much support it going back, I do want to make the point that it's important to get these things out into the committees. That's what the committees are for. It isn't, and we have a responsibility to assure our constituents, including groups that spoke and addressed the board through email as well, that we're not just rushing this through. The point was to put it in front of constituents and a committee. So just so, you know, the idea of half-baked, yeah, that's by definition. Because if we baked it, we would have baked it in a place that did not have full transparency. And that is not appropriate in the eyes of audit committee. We wanted to get it out to committee. So just a little background on that as well. Thank you.
Thank you. Vice Chair Carey.
Thank you, Chair. Yeah, I would just I'd echo what Vice Chair Hart said, which is there are some functions in audit that do need to be private, but there's a lot going on in audit that absolutely no reason why this rule could not have been given to this committee or any other committee from the get-go, and have us formulate that policy in with the light of day and with the transparency that I think more of our rules need to invite. But I am grateful for the opportunity to have this come to the committee. I do support this motion. One, because it'll save us about an hour and a half worth of debate today. I have several, I counted 47 proposed changes to this. So I'm grateful that this will be going back, I hope, if the vote goes that way. And more of us can have input into the formulation of this rule. Thank you.
Thank you. Member Wood, we never really stated your motion here. We just want, let me make sure it's clear, then we'll get you to speak to your motion. How's that?
Okay.
Okay, so the motion on before the committee is that the committee postpone discussion and ask staff to bring the rule back to a future committee meeting. Member Wood.
Yes, thank you. And thank you. I am really horrible at doing the thank yous first. I'm like, just get to the business. So thank you for your reasoning and understanding. I value the fact that you are trying to have local control. I have to say the most gratifying part of my job is when someone calls frustrated and I can say, you know, that's not really the role of the state board, but let me connect you to the right person. And then they'll call back and they'll be like, you fixed my problem. And I'm like, I didn't do anything. I just knew the process. And so if we can help people understand how to navigate the process better, we all win because they're happier. The right people are doing the answering. So thank you for your work. And I'm sorry, just I'm not very fluffy. You'll never see pink decorations from me. But also I appreciate where you're coming from. I didn't actually understand that this originated from the audit committee. So I appreciate that there is a process. Everything has to come to here. And so if we're good with taking the time outside to fix it and help people get it right, so that our districts know what they need. I talked to representative from Davis, a school board member this morning from Davis, and she said she had been put in charge of the hotline when she first ran. And so she had come up with help them approve their policy and get it to move. And she loved the fact, she says, actually our abuse hotline right now is hidden in numerous layers. And so if all this does is get those numbers to the forefront for our parents, we're better off. So I look forward to further discussions.
Okay, seeing no other lights, let's go ahead and put a vote that the committee postpone discussion of R277-123 and ask staff to bring the rule back to a future committee meeting. All in favor, say aye. Aye. That passes unanimously. Thank you. Let's move on to agenda item 1.3. R277-113 LEA fiscal and auditing policies. And again, we have Ben.
Chair, I don't know if this is appropriate or not, but we have Superintendent Gina Butters here for her matter. Would it be appropriate to take that in advance so she's just not sitting there in the waiting for her matter to be called forward?
I appreciate that. I know we were hoping that Superintendent Sid Dixon could join. I think that's what we were waiting for, but if
Our team should be pretty quick.
Need to be tabled.
No, because we have the matter that involves Sam's part of the rule. Yes, so
Delete the hotline part.
So yes, I don't want to keep Superintendent Butters waiting. I had been asked, I know Sid wanted to be here. Okay, let's go to 113 and then we'll see if Superintendent Dixon is close. Okay. Ben, go ahead.
Okay, thank you, Chair. So if I kind of want to direct your attention on this to draft 2, anticipating that 123 might be moved out, we prepared a draft 2 which takes out the language or reinstates the language on the LEA hotlines. And so the only changes that you're going to see in this rule at this point is at the very end, or near the second to last section, I should say, which is language that was previously that talks about flexible use of LEA funds. My understanding is that the legislature took this language out of the code, possibly inadvertently, and then during the last special session, reinstated the language in the code. So we had deleted the language from our rule because following on the legislature's lead, but now that it's been reinstated, this is the exact language that was in the rule before. I'm not. So it starts on line 517, and goes through the end of that section, or 538. So that would be the proposal here, is that we reinstate that language, and that if you make a motion for draft 2, that will accomplish that without taking out the language that would have gone to the other rule.
Thank you. Are there, you want to process for a second? Sure.
And so the blue language is supposed to be back in. You want that?
Yes, that's the language that we were going to move to.
Matt?
Yes, please, Member Lear.
A procedural question. I don't know if this is point of order or what it is, but so if we have concerns about the language beginning on 377, should we address these now, or should we wait till after we discuss 123 and see what appropriate language might be in there that comes from 123? What's the best way to do that?
Is that the language that's being removed?
So that's the language on the LEA hotline. So I would think that, given that you're asking staff to kind of rethink that we would probably delay that discussion. This is the current requirement, and we're just, this would just leave the status quo
Leaving
until
the
we get
status
that
quo.
discussion.
Because I'm not comfortable with this in a couple of not huge, but significant ways. So I'm not comfortable with exactly this language, but I don't want to necessarily belabor this discussion from earlier that we weren't going to discuss. And so if it's going to come back to us in the next month, I'm willing to leave it alone for now. So all of you are suggesting that's the best way to go. Okay. All right, then that's fine. Go ahead. And I interrupted you. I did have a couple of questions about even the language that was added at the very end, but I'll let you finish your introduction and not interrupt you again.
The introduction is over. I thought that you just had that. So anyway, no, finish with continue with your question.
Okay.
And then we'll go to Member Wood.
I know after all this time, I should be probably more conversant with some of these phrases and terms, but I'm not, or I've forgotten. So I just wanted a little bit of an explanation of sort of the meaning of some of these terms. And LEA I'm just starting on line 518, where the underlined section starts. May reallocate funds for flexible uses as described in section 53F. And I went to 53F, which gave me no help in terms of really clarifying language. And so I wondered if whoever is the finance person who maybe rewrote this or revised this could help me reallocate funds for flexible uses. Could somebody give me an example of that?
Sam Uri is the staff member that requested this. I will say, I think it gives a lot of flexibility, so long as it's not one of the two things that statute says you can't use it. can't transfer
That
from.
makes, I just write,
Although Neil Stevens has his hand raised, so
okay.
hopefully he can give you a good
If
answer on
someone can
that.
give me a layman's kind of discussion of the school finance language, that would be helpful.
So this origination board and the legislative text currently essentially allows them to transfer restricted funds into the general fund for any purposes needed in the general fund. So essentially, in practicality, you could transfer funds from CTE or special education into the general fund to be used for whatever purposes necessary in that fund, essentially used for general education purposes. That's the intent of this, and that's the intent of the current legislative text as well.
Okay, and just to clarify, because I asked for an example, but maybe special education is not the best example because it would have to be the state special ed funds, right? Not
Correct.
federal.
Correct.
Okay. All right, that helps me. Let me see if I think I had one other thing written down. Okay, I had something about, and it was late last night, so forgive me. Formula-based funds. Where was that in this? Formula-based program.
So that's all of your minimum school programs or related to basic programs in the minimum school program that are calculated by formula rather than a stipend, such as in special ed, we have the educator stipends at year end. That's a set amount that wouldn't be transferable out because it's a stipend of $200 per educator. So that doesn't
Gotcha.
apply in this situation.
Formula-based is maybe not always a stipend, but sometimes a stipend based or a predetermined by the legislature amount. Is that what you're saying?
Yeah, where the
Am I
legislature
kind of getting you?
legislature
Okay.
not appropriate a WPUs, they appropriate a fixed amount, regardless of WPUs or the LEA, and then we distribute it based on that dictation or legislative text.
Thank you. I think that clarifies for me. Thank you very much.
Sure.
Thanks, Matt.
Any others? Let's go, Member Wood, and then we'll go back to wherever.
This is just an education question. Does the state require maintenance of effort with our special education funds, or is that a federal law only?
Maintenance of effort is satisfied on the federal level with the use of state special education funds.
Okay, so it's a federal requirement, but we have to have those funds. And so this would not allow anything that would reduce that maintenance of effort. Okay.
That's correct.
Because that's in the code. So second question back to, am I correct the assumption that the blue language is currently state, that's current rule, right? The requirement is for a hotline. Okay, so that is currently in state rule. Okay, perfect. Thank you.
Okay. I don't see any questions. There's two possible motions that we could give. We're hoping for Member Lear.
A motion that I move that the committee approve R277-113 LEA fiscal and auditing policies draft 2. Okay. Draft 2 on first reading and forward to the board for approval on second and final reading.
Thank you, Member Lear. The motion before the committee is that the committee approve R277-113 LEA fiscal and auditing policies draft 2 on first reading and forward to the board for approval on second and final reading. Any discussion to this motion? Member Lear, your light's on. I don't know if that means, okay,
My motion,
please.
if I can briefly, because again, we've spoken a lot to this rule we weren't going to speak about, but I'd like to say that this is with the provision that we will be able to revisit this language when we talk again, because I'm not comfortable with this language, the blue language that's in there now, and especially having heard from many of the same people you've heard from.
Thank you.
I just
Member
want
Wood.
to thank Ben for reading our minds and having draft 2 prepared.
Thank you. The motion is on the floor with no further discussion. Committee members, all in favor say aye. Aye, that passes unanimously. I did get, moving on to the next agenda item. This is the Weber School District. I did get an update that Superintendent Dixon will be here closer to 10. I'm actually gonna, I'm going to defer. We don't do this very often. We're gonna defer to Superintendent Butters. Would you like to wait? We can skip this agenda item, or would you like to move forward? What would you like to do? You're glad to move forward and glad to wait.
Just go ahead. and-
Very complicated. Let's go ahead and, okay, we'll go ahead and wait. The discussion is riveting. I know you're enjoying it. Okay, let's move on then to agenda item 1.5. And when Superintendent Dixon gets here, we'll jump back to 1.4. 1.5 is, excuse me, 1.5 is R277-316, professional standards and training for non-licensed employees and volunteers. And again, we have Ben to tee us up.
Thank you, Chair. So R277-316 is a couple months away from when it's due for its 5-year review. So we're bringing this rule up for continuation. As I reviewed this rule, I felt that it would be appropriate to recommend some what I think are mostly non-substantive changes, but that would help the language in here. So if you look through it, you'll see that there were a couple statutes in the authority and purpose that didn't really relate to the main purpose of this rule. So the recommendation is to delete lines 8 through 14. I've reworded the purpose language a little bit on lines 23 through 28 is the recommendation. And then we've also added an oversight category. This would be category 2, primarily local control, and then we generally offer feedback and help if LEAs have questions on what's required for this. In the definition sections, I brought in a couple definitions that we use for the UPAC rules on background checks, because I thought that would help bring some clarity here. And also, this rule has some references to requirements for licensed educators. Those requirements are covered in the UPAC rules on background checks. And so my recommendation is to delete that language and make this focused on what the title is, and that's that this rule deals with non-licensed employees at LEAs. So I have recommended deleting the language on licensed educators. There's a few other changes throughout, just tightening up language that I think will help bring clarity. I'm happy to answer any questions that you have about my recommendations on the language here, but essentially we're asking that the committee continue this rule and adopt the recommended changes.
Thank you, Ben. It looks like we have questions first from Vice Chair Carey, and then we'll go to Member Lear.
Thank you, Chair. Director Rasmussen, I know this rule pertains to non-licensed employees, but I was attending a meeting where it was shared that we have 55 educators across the state who do not have a background check, even though it's required by law and they're in the classroom. And apparently there's no follow-up or sanction for that. Otherwise, I don't think these LEAs would be doing it. But here we're saying the same thing now for non-licensed employees, that they have to undergo a background check. How do we know if that background check isn't being done? What is the follow-up? What is the, obviously the legislature thinks this is important. They want it. And if it's not being done, do we have anything in rule that says this is going to happen?
I mean, I guess this is one of those things where you look at the oversight category. We don't have a lot of funds to enforce this. This is following up and kind of clarifying the legislature's mandates on conducting background checks for all employees. But at this point, this is primarily a local control issue. We don't have staff from LEA that are telling LEAs how to handle their non-licensed employees. I don't think many of the LEAs would want that. But with regards to your question on the licensed personnel, I haven't seen that list as of late. But if a teacher's in the classroom and doesn't have a license, my understanding is they don't get funded for that teacher. So there is a financial consequence if you have an unlicensed educator in the classroom is my understanding. So there would be some penalty for that. But that is something that I can look at the list, and we have from time to time followed up on those lists to make sure that unlicensed educator issue is addressed. And just by chance, we have Malia Height joining us, probably has a few thoughts of her own.
Can I ask, and Vice Chair Carey, if I missed something here, I'm curious, Ben, if you could help us, or Malia. I get the licensed part. What about those? Do we have any teeth when it comes to those without background checks? How are they getting through? I guess that's a question for me that I heard. Like, well, the piece that I.
Are you talking
That's stuck
about
in my
licensed employees or non-licensed?
I'm talking
employees?
about employees who are in the school, licensed or non-licensed. There are a handful that either do not have or have not cleared. I'm not sure, Vice Chair Carey, what you did not have background checks. And I think, how does that get
So
through?
we have a lot of teeth when it comes to the licensed employees, because we have the licensing staff, we have the UPEC staff that can follow up on those issues. We have R277114, which you're going to be talking about a little bit later on in this committee, which prescribes procedures that if there were a major issue there, we could certainly take corrective action against an LEA. So there's a lot of there is teeth there, a lot with licensed employees. With non-licensed employees, you have this rule that kind of sets some rules, but it's like a lot of Category 2 rules. It's primarily a local issue that the board does not have a lot of teeth on.
So this non-licensed addition here, or sorry, maybe I'm reading this wrong. This rule is not going to give us more teeth for the non-licensed employees, or is it?
I mean, no.
Okay. Thank you. I'm sorry to derail your question, Vice Chair Carey. Will you, if you have because I don't remember what the rest of your question was. Dr. Height is here. If you have any other questions, please ask.
Well, I would love to hear the question again, because there've been several topics.
Dr. Height, yep. The question was just for non-licensed employees. This rule requires individuals are appropriately background checked, and then some other things. If that's not happening at an LEA, what, if any, tools does this board have to help with compliance?
Yeah, so Malia Height, Executive Coordinator of Educator Licensing. So the law that governs non-licensed employee background checks is 53G-11-402. And that is strictly under the purview of the employing LEA. And so it's their responsibility to ensure that, there it is in line 23, that their employees have the appropriate background checks. Something that is maybe important to know is that the FBI has extremely strict rules and laws around who has access to individuals' criminal history. And so if an individual allows an employing LEA access to their criminal history, they can't share that criminal history with the USBE for the purposes of licensing. We have to keep those kind of background checks separate. So to say that there are certain individuals who don't have a background check in an LEA is maybe untrue, because we may not have a record of it in USBE, but the employing LEA almost always has a background check that they have access to, that they have ensured that that person is safe before they walk into the classroom.
Member Lear.
Yes, and I just want to add a little bit about that background check of non-licensed employee concern, because I've looked at it from the bureaucrat's perspective. I've looked at it from the private attorney perspective. And I think people have in their heads that this is a sort of a one and done, punch it into a system, and then you know immediately if the person has a background check. What happens is in reality, and maybe some of you do know this because you're working in schools, but you hire a coach and you tell that coach to get his background check done, or her background check done. And she says, sure, I will. And then she gets busy. And you don't go back to him every day saying, have you done your background check? You done your background check? And so occasionally And maybe you do. Maybe if you're really conscientious like Matt, you do. But if you have a lot of coaches like Skyline High School, sorry, not picking out Skyline High as a bad guy in any way, but if you you have a lot of coaches, and so it's hard to get them, make sure every single one, temporary, short-term, semi-volunteer, is getting a background check. So I think that's an important, it's not a super slick process, much better than it used to be, but it's not as easy as some people think. So I wanted to add that comment about my experience. I had a completely different question, Malia, on line 65. It talks about defining a licensed educator means an individual who holds a valid Utah educator license and has satisfied all requirements to be a licensed educator. So I'm wondering where the people who are in process fall. Are they under the purview of getting background checked by the LEA, or are they under our? Are they should they have been background checked as a licensed, even though they're not fully licensed?
Chair, may I?
Oh, and I'm sorry, that was
Please.
It's okay.
through the chair.
Yeah. Yeah. So an individual who is in the process of obtaining their license would be considered an unlicensed educator. We have deadlines that we assure that somebody who's in a licensed position has a valid educator license that's active. We've got one coming up. It's October 10th is the beginning of the school year check. And so before they're licensed, they would fall under the employee or the employer responsibility to ensure that that individual is also licensed or also background checked.
And our LEAs in our office very clear and clued into when that person turns over from a employee to a licensed educator.
The LEAs are very aware of when that happens because there is a significant amount of funding associated with a licensed employee versus a non-licensed employee.
So I don't know if that nuance should be picked up in line 64 or not, or if you think it's adequately covered.
I think it's fine. I think it's fine.
Okay. And
Have we had concern from the field saying, hey, I personally haven't reached out and asked, but I'm nothing compared to the field. You know what I mean? Like, have you had people saying, hey, what does this mean?
Yeah, no, we certainly have not. We train on background checks multiple times throughout the year, both in the charter arena and the district arena, and have multiple trainings posted online that are available to HR directors who are typically and charter directors are the ones that are interested in this kind of information. There's not been any question or request for additional clarity.
And thank you. I will leave it alone for now. I think it's an example of what I said to begin with. It's not as slick and there's not such a bright line test. We're big fans of that, but there's not such a bright line test sometimes. I had a couple more questions, not quite so difficult. Line 74 talks about an employee, non-licensed public education employee, public education employee. These are the people who would be employee of an LEA who does not hold a current background, who does not hold a license, is a contract employee. Do you think, and I don't know whose this question should go to, maybe Ben, maybe Malia, but I'm just wondering if it's clear to LEAs that this means if you pay the person anything, a stipend, he's a contract employee, that person needs a background check, as opposed to switching over to the volunteer who has to have significant unsupervised access to students. So is just putting in a contract employee adequate to cover all the employee? And maybe this is a good Matt and Molly question. Is that an adequate term that covers all of your employees, or is there a different kind of employment that could be stated there that's more clear?
I mean, I think the law is pretty clear. I mean, this is the same language that's used in 53G11-402, which is what the legislature's background
Never
requirement
mind.
is.
Then if it's as good as the legislator's language, then okay. That's,
I-
I didn't check that.
Yeah, these are the categories we use, and there isn't anybody that we've found fall outside of those categories.
Even though somebody arguably paid with a stipend is not really
Right.
you're just, but you as LEA directors would make sure that
Oh,
every
yeah.
person you pay any money to gets a background check.
Oh, yeah. Without a doubt. I mean, yes.
I won't go off on my rant about the limitations of background checks right now. Spare you that. But, and anyway, I just wanted to make sure that was kind of thought through. And then on line 80, this is the last point I have. We want to change that terminology. We don't use the Utah State Office of Education anymore. We don't use regional service centers anymore. So if you'll just update that language. I didn't have time to do my regular nitpicking of rules this week, so sorry. Thank you. That's all I had.
Carol, like Matt and I were both talking, volunteer means a volunteer who may be given significant unsupervised access to children. We actually don't allow our volunteers to have unsupervised access, not in our own policies. So this may be the definition for a volunteer, but many LEAs, in fact, everyone that I've worked for doesn't allow that.
Even the soccer coach who pulls the kid aside and says, "Let me talk to you about."
That's not a volunteer. We put them on because then they have to sign all the
So
agreements.
Money?
Probably yes, a stipend. We don't really do if they're a volunteer, they're under the supervision of someone who is an employee. They're never allowed unsupervised access.
Okay.
That's just
I'll
too
have to
risky.
take you for, I happen to agree with you. I'm just thinking of reality and watching a lot of soccer games. So, all right, thank you. Thanks. Those were my concerns and questions about 113 or whatever one we're doing, 114. 316, never mind.
316.
Oh, dyslexic there.
Okay. Member Wood.
Just a question, and I know it's referred to in 53G11-402, but since this is coming back for its 5-year review, would it be appropriate at all to add in the language from the last session where an LEA may not allow, require payment for the background check?
I think that's already covered in statute. I think that's sufficient, yeah.
Any other comments, or if somebody's comfortable? I know, I keep checking in there. All I see is balloons.
I'll make the motion.
Thank you, Member Hart.
Oops. I move that the committee continue and approve R277-316 professional standards and training for non-licensed employees and volunteers, draft 1 on first reading and forward to the board for continuation and approval on second and final reading.
Thank you, Member Hart. The motion before the committee is that the committee continue and approve R277-316 professional standards and training for non-licensed employees and volunteers, draft 1 on first reading and forward to the board for continuation and approval on second and final reading. Any discussion to that? Seeing none, all in favor say aye. Aye. That sounds unanimous. Thank you. We will take just a few minute break to just gather some things, and hopefully we'll jump back to 1.4.
She's on her way.
Committee, let's go ahead and take our seats. We are going to move forward with agenda item 1.4. Typically, we invite the superintendent of the district to join us up here at the table. So we have Superintendent Butters here. This is agenda item 1.4. This is Weber School District, Westfield High School waiver request. We also have
Ashley's right there.
Oh, AG Beal is online. So, Ashley, if you will tee us up, and then we'll direct any questions that we have to you or Superintendent Butters and go from there. Thank you.
Sounds great. Thanks, Chair Hymas. So this is a waiver request for made under Rule R277-121 for a waiver of Rule R277-419-4, which is the 180 days requirement. This one is kind of standard for what we do, but slightly different rather than like a 4-day school week. The school in this case just opened this year. It's a brand new school. It was under construction at the beginning of the school year, and due to some construction delays, occupancy was not able to happen quite as early as the school thought that it would be able to. And so the school started, I believe, 8 days late. The superintendent can correct me if I'm wrong there, but 8 days late. And so they would not meet the 180 days requirement. So they are seeking a waiver for that. And in exchange to kind of meet, although we no longer have that 990-hour requirement, as we've discussed previously, a lot of schools use that as a benchmark to say, even though we're not meeting the 180 days, we're still meeting the 990 hours. Westfield has adjusted their schedule to start their day 5 minutes earlier and reduce their lunches by 5 minutes so that they'll add 10 minutes of instructional time to every day so that they'll still be meeting that 990-hour threshold.
Thank you, Ashley. We've got a question from, let me just ask, can we get Superintendent Butters, is there anything you'd like to add before we open up for questions?
There we go. Okay, sorry about that. First of all, I just want to thank you for allowing me to come before you today, Chair Hymas, and the rest of the committee. No, she has articulated very well the predicament that we find ourselves in, and so everything that she relayed was accurate. One thing that I would add is, as we started our projects in Weber School District, just for a little context, if I could provide to the committee, we have 4 buildings under construction at the same time in Weber School District. The growth that we're experiencing on the west side of our district's been exponential, and 3 schools have been under construction in a very centralized area of West Haven. An elementary school, a junior high school, and Westfield High, which has been spoken to. We have been experiencing delays like everybody has with supply chain, and the biggest issue we faced early on that put us behind and put us in this predicament was some of the water mitigation issues we dealt with on the west side. It put us behind almost 160 days at Westfield. So to open 8 days late, I'm very proud of that, but I know it's problematic, right? I'm very proud of that. The other 2 schools in question opened on time, although they are still under construction in some parts of the building, but we worked like mad, and I'm very proud of the efforts of our district, but I want to apologize about coming before you after the fact. I own my frailty on that part, and my just being consumed by what we were dealing with, and I apologize for putting this committee in that situation.
I don't know if apologies are necessary.
They are. I feel like they are.
I think we've seen this. Member Hart.
So I've been in this predicament before in another state, and the decision was to do it was actually 10 days for us, and it was 10 Saturdays. And that was a disaster,
Yeah.
especially in the Deep South where Saturday is reserved for SEC
Oh, I
football.
bet.
So my question is, I have a question and then something else, but are you doing that for the entire year or a semester or?
In terms of adding time back,
Yeah.
we're doing it for the entire year.
geez.
Yes, yes.
Okay.
We've adjusted the school schedule all the way through to the final day of school.
Yeah, yeah. No, I empathize. It's, that happens and nobody wants it to happen. And, you do everything in your power, you're personally, putting together desks and trying to get those spaces open. I appreciate the mitigation, but at the end of the day, I think that that's something that you can really rely on your educators and your school staff to mitigate those delays. I have zero concerns about this. So unless there are any other questions, I'm ready to make a motion.
Before you do, Member Hart, do you mind if I know Superintendent Dixon is joining us. We had to switch brain. You know what I mean? Like you go from one thing to the other, and I'm sorry, Superintendent Dixon, but I know you've been working with Weber School District and wondered if you had anything to say on the matter that would enlighten the committee. Thank you.
Thank you, Chair Hymas. I appreciate that. I have had consistent conversations with Superintendent Butters from I think it was midsummer, maybe, just talking about the schedule of the buildings. And it's pretty exciting that 2 out of the 3 started on time, given the last minute construction foibles that tend to happen. But I just want to vouch for the work of Superintendent Butters, the Weber School District Board, and take ownership for some of the messaging that we sent to Superintendent Butters when she was trying to work through this, truly doing her due diligence, making sure every I was dotted and T was crossed. And when it came to the waiver process, I erred in not checking in with Ashley and with our AAG bill, who would have directed me to do something different that I would have then directed Superintendent Butters. So we're here in part for the miscommunication that I sent. And I just appreciate how Superintendent Butters has leaned in to make sure that she's doing everything she can on behalf of the kids of her district who get to attend this beautiful new school. So thank you to her for her great leadership.
Thank you. Please.
Yes, I just, listen, she is so kind and I rely so much on her stellar leadership and the leadership of this board. And I don't say that lightly. This was my on me. So I appreciate that fully, that she would be here to support us. But I need to sit in this particular situation. And so let me. Yeah.
We'll blame both of you. I do appreciate, though, obviously this is not something that we want to see, but we are grateful the steps that have been taken. And I guess when I say we, I mean and I believe that the committee agrees, but the steps that have been taken to secure and value academic time in these laws, instead of just saying, you know what, we're seeking a waiver, we didn't have time, right? We're taking steps. And so that makes this vote much easier for me to say, no, we have a superintendent who cares about every school. And even though there were things out of your control, you still care about and value academic time. So thank you for that. Okay. With that, I believe Member Hart.
I move that the committee approve Weber School District Westfield High School's request for a waiver from R277 419-4 and forward to the board for approval.
Thank you, Member Hart. I just texted Vice Chair Carey. He wanted to vote on this one. I know he met with you.
He did, and he also attended our board meeting Wednesday night where our board would discuss this item as an agenda item. So I appreciated his presence there as well.
Yeah. And we appreciate the information that you shared, and he shared it with the committee as well. So
Okay, great.
Can I ask a question
Please.
regarding this motion? Is this, would it be more clear to say this waiver is for this 2024-2025 school year?
I defer to AAG Beal.
The effective dates of the waiver always get put into the waiver agreement. So if you want to include it in the motion, you can, but all those terms specifically will always get included in the waiver agreement.
Member Lear.
If I can speak to that, I think that's a good idea because it says to the public, this is not a blanket, even though they would not look at the waiver agreement or know there was one. So I think it would be helpful to put it in the motion. Is that a
Well,
big deal?
Wait a minute, what?
Or they want,
It just is for the current school year.
It would look like this.
Oh, that's fine.
okay.
I just think it's.
Does this look clear? So let me, Member Hart, are you comfortable with that? Let me restate the motion. The motion is that the committee approve Weber School District's request for a waiver from R277-4194 for the 2024-25 school year and forward to the board for approval. We'll do a roll call vote. Member Wood.
Yes.
Member Lear. Member Lear is a yes. Member Hart and Member Carey. Member Hart and Member Carey are yes. I'm a yes. That passes unanimously. Thank you, Superintendent Butters. Thank you, Superintendent Dixon.
Thank you so much.
Okay. Moving on to agenda item 1.6, R277-114, response to compliance and related issues. And am I reading this correct, Angie?
Yeah, that's correct.
Okay.
I may. Thank you.
Thank you.
Angie Stallings, Deputy Superintendent of Policy, presenting my last rule, which is a little weird and surreal. But R277-114, you may remember, because we discussed it quite a bit at the end of last year and early this year, was recently updated and passed by the board in January, and I believe the new version took effect in March. Since the passage of the new provisions, there is a new requirement, or new as of March 2024, that requires the superintendent, aka staff, to provide written notice 30 days before issuing a finding or corrective action plan. And some of our staff, specifically those that work heavily in the federal programs area, were not aware of the 30-day requirement and didn't have an opportunity to kind of think through the intended or unintended consequences of applying the 30-day waiver requirement to federal programs. After they did so, they had a recommendation that we make an exception that the 30-day notice, and just as a reminder, it would, before you even get to the 30-day written notice requirement, staff are generally doing either on-site or desk monitoring, and they are in communication with the LEA back and forth before any corrective action plan is drafted and sent. So the LEAs should have had an opportunity to provide verbal or even written response before a corrective action plan is done. The 30 days, and again, what we're talking about is this subsection 3A. It's right now, I think it's 2B, but it's the requirements on lines 88 through 94. That the concern is that it conflicts with federal monitoring requirements, and that they wanted to bring this forward because in full transparency, their interpretation is that this is out of compliance with federal law, and so they are not doing it, and they wanted LEAs to have that transparency and not rely on a dispute of which law supersedes which, to just clearly state that these provisions do not apply to federal programs. And so that's the background. Assistant Superintendent Leah Voorhees, of course, you can see she's here in the audience. She knows much more about this issue than I do. And I know I saw Neil Stevens in the Zoom room earlier. I wouldn't be surprised if he's still there. He's one of our federal monitors. He is there. He's appearing now. And so those two will be the best to speak to the technical issues and, bingo, that's it.
Okay, we will wait for questions and then address the staff. One thing that I was just reminded, I apologize, we had public comment for this. We should have had that before Angie went. I apologize. But if we could invite, I believe, Royce Van Tassel, you want to speak to this rule, is that correct? Royce, okay, go ahead.
Again, thank you, Royce Van Tassel, Utah Association of Public Charter Schools. I've had actually very good conversations with your staff back and forth. They've been very helpful in providing some of the guidance documents from the Office of Special Education Programs around that go into whether this 30-day written notice should or shouldn't be provided. I mean, obviously there is room for interpretation here. This suggests the possibility, as it's being written right now. I mean, I will say that line 85 makes complete sense. I completely understand that. It's just acknowledging that federal law supersedes state law. But lines 98 to 101, I think, go a step further because it is not just saying federal, but this is including local programs that may supplement a federal program. And so we're talking, for example, about state special ed dollars and are there violations associated with that. Now, the federal guidance documents leave open a wide range of timeframes in which an LEA needs to receive that finding, and in which the state, the SEA, needs to impose a corrective action plan. And my concern, as I've spoken with your staff, is that I don't think anyone wants a situation where that corrective action plan, which can, some of them are very simple, others are much more complex and potentially heavy, for lack of a better word. I don't think anyone wants a circumstance where that corrective action plan comes as a surprise. And so the 30-day notice that says, hey, this may be coming, be aware, let's maybe think about this, seems appropriate. There are provisions in federal guidance that allow the LEA to work to resolve that. The finding will still have to be issued, but even before that corrective action plan is imposed, that there is an opportunity for the LEA to resolve that. And I just think that having some sort of a process so that the LEA doesn't feel surprised would be helpful. And what we've got now that says, hey, you're going to get a 30-day notice avoids that surprise, which can get messy. And so my request is that as we're working through that, particularly on those state supplements to federal programs, that we make sure the process doesn't surprise somebody, because that can be problematic across a variety of dimensions. So thank you.
Thank you, Royce. We'll open it up to committee members for any questions of staff. I would like to, I'll ask staff. I don't see any lights yet, but Dr. Voorhees, we're going to have questions. So we might as well bring you forward. And of course, Neil Stevens online with us as well. There's obvious concern that people want a heads up. Whether or not we're hearing from public comment or not, people like a heads up. How is this protected? I mean, we talk about 30 days. I think it's reasonable. Can you speak to these lines, these newer lines, 98 through 101, that would still give LEAs proper notice in some of these areas? Maybe, and then maybe, if again, I'm asking multiple, but maybe you could give us an example of when somebody would not get proper notice, if there are any, please.
Yes, thank you, Chair Leah Voorhees, Assistant Superintendent of Student Support. So in student support, we issue a lot of many findings of noncompliance to LEAs. Lots of different federal programs, and in some cases state, but the majority federal, which is what the issue on the table is. This, I cannot think, Chair, of a time, at least not recently, and I'm old, so my memory's not awesome. But I cannot think of a recent time that an LEA did not know that a finding of noncompliance was coming. I think the super important issue here is in the current language of the rule, the reasoning for the 30 days was the next piece to resolve it informally. And that is not possible. And that gives LEAs a false sense of, I'm going to get on the phone, I'm going to get on a Zoom meeting with staff, and I'm going to be able to explain away the noncompliance, or I'm going to be able to agree to correct the noncompliance and not be issued a finding. And that is not possible. There's very specific guidance that is attached to our $150 million grant in IDEA that even if an LEA corrects, before the finding is issued, the finding has to be issued and it has to be reported to the Office of Special Education Programs, which is very confusing to LEAs if they don't get the finding immediately. And then there's another important issue related to waiting to issue the finding. And that's that when the finding involves, which is rare, but happens, when the finding involves denial of FAPE, the student has been determined to not receive the services and supports on their IEP. So they're being denied a free appropriate public education. They have to provide compensatory services to be able to place the student in their educational programming where they would have been if they had received those services and supports. If we wait to issue findings, the amount of compensatory education that the LEA has to provide increases, and it further increases the chances that the parent would request dispute resolution, such as a due process hearing on the matter, which they would have a right to because the student was denied a FAPE. So those are three, in my opinion, important reasons. Another thing that I think it's important for the committee and for the public, for LEAs to understand, is a finding of noncompliance in the perspective of, to use special education again, but it works similarly in title, but special education is ticky-tacky when it comes to noncompliance. If a date is not on the IEP, if all of the required members of the team have not signed the IEP, if a box isn't checked, that's noncompliant. That has to be reported to the Office of Special Education Programs, and it has to be corrected. And that requires we issue a finding. You get a formal letter And those of you who work in LEAs know you get a formal letter with my signature on it that says you had a box that was not checked. Check the box and send me the IEP showing the box checked. So in the perspective of OSEP, that's a finding, and we have to report it, and it has to be corrected in their language as soon as possible and no later than in 1 year. So the sooner the LEA gets that letter, the sooner they can correct, which meets the requirements of as soon as possible. But they also can't say, well, it's just a box, I'm going to fix it, and then we're done. They can fix it right then, but I still have to report it. Whether they fix it right there while I'm on scene and I've showed it to them or not, they're still going to get the formal letter. And they might get a letter that says, this noncompliance was identified, and then in the next paragraph, and it was corrected, no further action is needed. Thank you very much. Love ya, Leah. They might get that letter, but either way, they're going to get the letter with the finding. They cannot informally resolve it, which is what the rule currently says and is concerning. Does that begin or help or address the questions that you asked, Chair?
That overcapacitates my brain.
Do you want me to show you a letter?
No, I've seen a letter.
I got one today.
Yeah, I don't like it when I get
Yeah.
a letter, but I get that work needs to be done. So let me ask the question here, Leah. Dr. Voorhees, I'll try to be more formal. Lines 98 through 101, the addition here, subsection 3 does not apply to these, right? Legal requirements related to a federal program, legal requirements related to a state program. Does this not just fit already in line 85 with the federal, when it does not conflict with federal law or federal guidance? What would happen if we
Which
just,
line are you on?
what
Sorry, Chair.
would happen if we just removed lines 98 to 101?
Okay, 98 to 101.
So taking it back, but leaving this for you.
So leaving 85, the proposed 85,
Mhm.
and taking away 98 to 101. The issue that I see is that the possible confusion of LEAs related to the 30 days and the informal, where's the part that says informal resolution? Because there just isn't informal resolution. Okay, there you go, line 91. Try to resolve the issue informally. That
So we're talking about, and maybe I'm missing something, but we're talking about two different things. You mentioned a finding. When I spoke to others about this, the big concern was the cap, right? So I mean, talk about that a little bit. Is
Okay.
this right? Removing this, like, I get the finding. I think we all get the findings. Like, hey, here's a finding, take care of it. What I don't want to see, and luckily I don't think I've ever gotten one of those letters, boy, I hope I would recognize if I did, is, hey, here's your corrective action plan.
okay.
Can I only say one thing just quickly, because it's very technical. It's mostly to just reassure you, Leah, that, or Dr. Voorhees, that the statement on 85, when it does not conflict with federal law or federal guidance, does apply to subsection 2
Right.
as well. Okay, I
Yeah,
just wanted to
I
make
just
sure.
think it's confusing.
Oh.
It would be very confusing to LEAs because then they keep reading
Okay.
and they think, oh, I'm going to call Leah and try to get out of this or try to work around it. And then I have to refer them back to line 85 that
Right.
says, well, actually you can,
Right.
right? I mean, it's possible. I just think it's not clear, and clear is kind.
And that's why the
Yes.
recommendation for 90.
Yes.
Okay. Just
Clear,
wanted to-
yeah, I appreciate that. Clear is kind. You're right. I don't imagine, unless there's something conflicting in federal law, That's where I'm struggling to understand. Unless there's something conflicting, then why would we need to restate unless there is something that you're seeing in there that says, hey, we're going to follow federal law, and is there a little bit more of a squeeze that the state is putting on? That's what I'm wondering, that our agency is putting on top of federal law.
I don't think so.
Okay.
Because this is the way we're going to interact with LEAs. We're going to issue the letter, and at the bottom of the letter, it says next steps, correction of noncompliance. And then there are bullet points about the correction that is required and the dates that are required. And to your previous question, putting the two together, Chair, the corrective action plan is embedded in almost every letter in which we issue findings. The corrective action is embedded down at the bottom. It says, are there required trainings? Is there required comp ed? Where in the system do you have to fix this? What do you have to send us? It's the letter, this letter that I'm looking at is 5 pages long, and the corrective action plan is 3 bullets. So the issuance of all of the findings is you didn't check this box, you didn't check this box, you didn't have this person at the IEP, blah, 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 blah. And then here are the 3 things you need to do in order to fix it as soon as possible, right? So to your question about the corrective action plan, you get one every time I send you a letter. And I'm saying I because it's my name on the letter. Staff put it together, right? But it's my name on the letter. But the thing that I think is not clear to LEAs is, yes, the proposed language is when it doesn't conflict, but by keeping that phrase in there, there is possibly, probably, in my experience, not recognition that the finding is coming, it has to be corrected, and that's just the way it is.
Thank you. We have a questions or comment from Member Lear.
Well, and I was just my point is to support what Leah's comments, and to also say, I think it could be read by an LEA when it does not conflict with federal law or federal guidance before the superintendent places an oversight on a corrective action plan. I think that an LEA could readily read that and think there's not really a corrective action plan because I just have to do these 3 things. So that's not really a corrective action plan. So I think it's helpful to clarify that by adding the lines below. And I think we've had recent examples of the Utah Supreme Court saying you have to do it exactly the way the law is written. And I think that is really not always comfortable with lay people. Not that they make intentional mistakes or anything like that, but I think it's sometimes very important to clarify in a rule or in the Constitution or in a court finding, this is what the law requires, and there is no ability to give you any wiggle room or any grace. So I support this. Technical, yes. I don't feel like it is. I think, Matt, you said previously, or somebody said, I mean, it was Royce that said, it's sort of an in-your-face kind of a comment or a repetitive comment for LEAs, and they're a little bit put off by it. I feel like it's just making it crystal clear that Leah's department has no choice.
Thank you. Member Wood.
Thank you. So to clarify, if there is a finding in special education, there will be a corrective action plan. That may be go back and check a box.
Yep.
Okay. So I think in my uneducated, I've elevated a corrective action plan to this long process, horrible thing. Basically, you're saying, we found this, please correct it, done for some. Some may
Right.
be along involved.
Some may be long and involved.
But,
Yes.
but it can be as simple as, please check the box.
Yes.
Okay.
But
thank you.
either has to be done as soon as possible and no later than 1 year.
Okay, I've gone back to my letters and I've looked at them. And to be honest, the rule confuses me more than my letter that I get. I don't, I'm trying to figure out why it gets confusing, but I hope I never go to this rule to try to figure out what I'm supposed to do, and I just follow the letter. So I do think that there's something about it that confuses me as a practitioner. I just can't put my finger on it. Is that what you're kind of a little bit? There's just a lot of words
Yeah.
to say. Just the letters are extremely clear about, next steps, correction of noncompliance. And then they say that, they're able to help. Just please call.
Yeah, thank you. This is the problem when Molly sits right next to me. You should, yeah. Then we start talking like, what's going on in your, yeah, yeah. But no, this is, I'm not very good at articulating. I'm not sure why, in my opinion, it's the purpose of the change was to say, quite frankly, we have to follow federal law. That's why I'm saying if the rule was actually running fine, and it was going and everywhere was clear and we get these letters and we take care of them. And then we say, well, you have to understand that we have federal law involved. For me, like my amendments on this entire rule would be to scrap all the new changes except for line 85. Can we just scroll to 85? And I'm not making anything formal yet, but I would just add when it does not conflict with federal law. That's it. And then move on. Because like I said, I didn't see a problem with the rule before. I thought it was, granted, I don't go through and read it all the time, right? And then now we're saying, well, there's federal law to be there. So, and again, in my opinion, if we want clarity, then we just say, okay, we have to make you aware because it's not like we've been ignoring federal law to this point. Now we're just putting into rule. We want to make sure that you're aware that federal law supersedes. So again, that's where my mind is going. Nothing official yet, but that's where my mind is going is 85, just simply adding when it does not conflict with federal law. You look like you're ready, Dr. Voorhees, to say something about that. All right, am I just, I don't know.
No.
Member Lear.
Let me try one more time. And I hear what you're saying about how it doesn't, I think the part to me that doesn't make it crystal clear in line 85 is conflicts. When it does not conflict with federal law. I don't know how to rewrite it in the moment, but it could be something, it's not something that necessarily conflicts with federal law. It just, it doesn't give all the explanation of federal law. That's more what I'm not, where I'm disagreeing with you, where that doesn't leave line 85 sufficient, because it could be bigger than it's not an exact conflict. It's more of a federal law also requires. So to me, and I don't know if that helps or not, or makes it worse, and I'm not for rules that are unnecessary or are especially internally duplicative, but I think this just makes it crystal clear that there are things that are required by federal law that have to be done, period. And it doesn't, that puts aside that we could argue about is this a conflict or not. It's more a lack of full disclosure.
Could we just say at the beginning, if if the findings are federal law, this rule does not apply. So that I just stop reading if it's a federal rule that I'm trying to, or a federal issue that I'm trying to figure out. Like, I don't want to read halfway into the rule and then realize, oh, shoot, the first part of the decision tree is this federal or is this not? I get it. I mean, I definitely get it. I'm not going to solve anything. My problem is not going to be solved if I use what's in this rule and apply it to something in one of my federal programs. So I shouldn't even be opening this rule at that point. Like, it doesn't apply. So I don't want to read halfway through the rule and then find that. Anyway, that's just an idea.
So, going off of what Vice Chair Hart is saying, because at the beginning, as you start the top, it talks about this informal process, right? And so you're saying within the federal law, there is no informal process. And that starts, just trying to find it, 35, line 35, the superintendent may work informally with an oversight entity to resolve an alleged compliance issue. So already up in 35, we've got them thinking there's a process that I can go through. We don't need to do this. So I find what you're saying much more clear if we start with the do nots right before. I don't have proposed language yet, but I'm writing it up.
Member,
Just trying to buy you time.
member Lear.
No, I'm sorry.
Oh.
Thank you. The question I have is, I guess, for Leah and Neil primarily. Do you use or rely on 114 at all when you are monitoring federal programs?
We do. But that doesn't mean that if you rearrange it, that we still couldn't, because we re-reference 114 up in the, let me open that letter again, or let me flip to the letter that I'm looking at. So if there is in Member Wood's vernacular, a long, complicated corrective action plan, then we do reference 114 because there's the other provisions in 114 about being able to appeal, which actually there also is in the Code of Federal Regulations, but I don't think rearranging the language would supersede that. I mean, yeah.
Can I just say, my comment was more to the proposal that potentially we just start the rule out saying this rule does not apply to federal programs. And I wondered if doing that
sorry, I
would
misunderstood.
take away some of the some of the process that you're using in here. As that was my guess, is that some of the process is being relied upon, or else they would have probably just not cared about 114. Anyway.
Well, and that's where I'm leaning as a committee member is, yeah, I like what Molly has said here, just at the beginning, and then keep the rule, and maybe you're not saying that, but again, keep the rule as is. Like put at the beginning, federal law doesn't apply, and then we keep the rule as is.
So are you saying like a new line 34? Or are you saying up in the authority and purpose?
I would recommend we either do it in the authority purpose and or either do it in probably a new section 2 that just explicitly states that normally we would put it at the very end, but to avoid somebody reading all the way to the end, because normally we'll put this rule does not apply to, but I think it makes sense to put it at the very top. So it would be at the very top. And then the whole rule, you just wouldn't even rely on for federal monitoring.
So then for the purposes of federal monitoring, we would rely on the Uniform Grant Guidance and the Code of Federal Regulations when it comes to corrective action. And yeah, I would need to just like sit down with Laura Lee and Neil and make sure that we're on good ground, but it sounds reasonable.
Is this something that we would need to just give time? I don't know what the time sensitivity of this is. I like the original language anyway, so I'm happy to wait 5 years. But is this something that we can say, hey, can we look at this in November's committee meeting?
Yeah, we can certainly work on it for you, Chair.
Member Lear?
If it's that simple, maybe we could look at it by the end of the meeting. I don't know how long you want to process it longer than that. I am hypersensitive about this because it's not like Leah is dredging up a problem on a technicality. And I don't mean that anybody's suggesting she's not a professional in this world, but so we've had experiences with LEAs who wanted to pick apart every single word and argue that it didn't apply to the LEA in that way. We've seen that recently, and it's caused us lots and lots of consternation. So I am inclined to defer to Dr. Voorhees in her role and in her experience about what is most clear to LEAs who have chosen to pick apart the words for their own purposes. So I just want to if Leah is absolutely comfortable that doing it differently, staying at the beginning of the rule, making it clear the other piece that Angie added about letting readers know that what you described will be the applicable standard, and if that's clear enough and given the circumstances we've seen in the past and would have helped clarify it for LEAs in the past, then I'm comfortable going in that direction. But I'm also really hypersensitive to Leah's opinions, given that she's been our intermediary in these challenges we've had in the last couple of years.
Thank you, Member Lear. Member Wood, I see you have a comment, but I see that Neil Stevens has his hands up. Let's turn to him and then we'll hear from you.
Yes, thank you, committee. The one concern I have personally with putting the exception to this rule for federal program at the beginning is that we rely on Section 6 of this rule to implement the corrective action appeal process. So in uniform grant, non-uniform grants in EDGAR, so that's the general provision, education provisions at the federal level, it states that we have to provide a opportunity to appeal any adverse action that negatively affects the LEA. Corrective action, could it be one of those repayment of funds not used properly? Could it's another adverse action that we have to afford them to? So this Section 6 of the rule points us to Section for Board Rule 102, Section 3, that outlines a process for hearing appeals. So however we word this, we need to make sure that Section 6 still applies to federal programs for LEAs, so we can point to our federal partners when they monitor us or have concerns that we have a process to implement the federal requirement that we afford LEAs an appeal process when we bring forth adverse action to them.
Thank you.
Can I just?
Please.
And this will mostly be for Ben and Leah when Ben gets to take this rule over for next month. But potentially you could say only Section 6 or whatever the appeal section is applies. The rest of the rule does not apply to federal. So there's that option as well that could be worked on.
Member Wood.
Yeah, I was wondering if we could add it into the purpose statement on 18 and 19, but he has clarified that that would narrow it too much for what his needs are. So thank you for having him go first.
Yeah. So I don't know if there's like a formal.
We could do this motion. like have us work.
Okay, Member Hart.
Yeah, I like where this is going. As a board member, I feel like this would provide, if we look at what we can do in this space, it would provide more clarity to the field. And presumably that assists them in compliance, quite frankly. So I'd like to propose that the committee postpone discussion of R277-114 and ask staff to bring the rule back to the November committee meeting. Certainly in no way do I think that or want any, I want it to be clear. And if they don't get 30 days, they don't get 30 days. We need to understand that. And that needs to be clear. At the same time, our own rules should not overcomplicate the issue and should provide clear guidance, or else we wouldn't write a rule. We would just leave Edgar and blah, 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 and blah, 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 and law and that kind of thing. So I'm not looking at watering down or whatever. At the same time, I think it's clearer when we don't overextend ourselves. I would like to make a comment about guidance. Guidance anymore is like a willow tree. It just bends in the wind. We get guidance one day and then we get another guidance the next day. I mean, that is not to me as trustworthy as what is in the actual requirements, because to me, guidance has started to feel very political, and it's not helpful. So one thing that I'm concerned about is, well, the whole notion of guidance, but that we stay very clear and we stick with what is actually in regulation, and we stand fairly strong on what is, and we have just good boundaries for our folks. So that's just something I'd like to add into the conversation. But and that was speaking to my motion. The whole thing needs to be postponed until we have a little bit more clarity on the direction we're going.
Thank you, Member Hart. So the motion before the committee is that the committee postpone discussion of R277-114 and ask staff to bring the rule back to the November committee meeting. Seeing no lights, all in favor say aye.
Aye.
Aye. That passes with 4 ayes, and Member Carey is absent, so it passes unanimously. Thank you. And thank you, staff.
Oh, board member, may I make one comment related to that?
Please.
And thank you for indulging me. I just wanted to bring to your attention something that I mentioned in the email that I sent to everybody on Wednesday, but I wanted to just show it to you before, because if you don't know it's there, you may not know to look for it. But beginning this month, staff are preparing proactively some information to help explain the recommendations that are coming forward with board rules that bring in an oversight category. So as you might have seen just a moment ago at that 114, it did include an oversight category recommendation of level 4, because it is our, the monitoring and corrective action rule. And we were hoping that this kind of information from staff would be helpful. And also, if you look at the second page, it gives you a matrix or a visualization of what the staff are reviewing to make a determination about whether it's a 1, 2, 3, or 4, with the hope that this will just help the dialogue as the board might be discussing what category ultimately is most effective. You will not see these quad charts if the rule is not amending or adding the rule. So if you look at a rule in the future and you're like, well, this one doesn't have the quad chart, it's because there are no amendments to include a new category. And thank you for giving me the opportunity to share that.
Thank you. Let's move on to agenda item 1.7, board policy 3006, data governance plan. And Katie, are you taking this one? Thank you, Katie Chalice.
Good morning, committee. Katie Chalice, Director of Privacy. This is an amendment to an existing policy, Board Policy 3006. The impetus for making these changes was the committee's conversation, I believe 2 months ago, about adding language that sort of allowed for, oh yeah, there's the language there, thank you, to prepare draft amendments to Board Policy 3006 to provide a process specific to sharing data internally with LEAs, which prioritizes student data privacy. This came about in your conversation surrounding the data request from Jordan School District for validating, or I guess challenging the calculation for charter school funding. So in our process of trying to meet the committee's motion, we did a few things. The primary change is found in the data disclosure section, which begins on line 108. In order to accommodate what we understood the committee's request to be, we had to make some pretty significant changes to the structure here, but in practice, it won't change our behavior as staff in terms of how we bring data sharing agreements to you and whatnot, with the exception of adding a little bit more clarity. We attempted to address your request in subsection 11, I believe, starting on line 181. So that's the primary section of change. There's also lots of small changes, updating the job titles for myself and Aaron Breff, making some other clarifying changes, but that's the summary. And I'm happy to take any questions or whatever you'd like, Chair.
Thank you for that. Looks like we have a question first from Vice Chair Carey.
Yeah. Hi, Director Chalice. Line 169. The way I read that, and I don't think this is what was intended, but the way I read that, it says USBE leadership shall approve requests from board members for internal data. The way I read that, it means that if I request internal data, board leadership doesn't have a discretion. They have to give me that data. I don't think that was your intention, but is that a fair reading of that?
It was not the intention. There's similar language.
I mean, I wish it was the intention, but that would be my preference, but I don't think that was the.
I think the intention was, so like if you look at line 167, same thing here, the Director of Data and Statistics and Director of Privacy shall approve requests for, I don't believe the intention was to obligate us to make those approvals. It was to indicate who will do the approving. So and Ben, unfortunately, is not here. He was the one that kind of landed on that language.
I would, my recommendation would be that be cleaned up. I don't have a formal motion on the language cleanup, but I would want to discuss, in addition to having board leadership be the pathway for approval requests, I think that it would be board leadership or a majority of the full board that should be able to do that. Would that pose any concerns on your end?
I don't think so. For the group's awareness, internal data is defined. Let me find it. Yes, thank you.
154.
Right. So this is internal data is basically the stuff we don't want to be traditionally exposed publicly. PII of students, student level data, or aggregate data that doesn't have disclosure avoidance applied. I bring this up because if I believe it would be uncommon for a board member to seek this information. As your privacy director, I think it would, in most cases, be inappropriate for a board member to have that information.
Then why allow board leadership to allow that to get into the open?
I don't know. That's a historical piece that's been in the policy that I'm not aware of the discussion that surrounded that. Personally, again, as your director of privacy, I would prefer that that go through myself and Aaron Bruff, for example, because that is such an unusual request for a board member to have that level of information.
In the time that you've been here, Chair, may I continue? In the time that you've been here, have you ever had a request from a board member or even board leadership for that kind of information on a student?
No. I could ask, Director Bruff would be better able to speak to that, but no, in my time, not that I'm aware of.
Yeah, and my suspicion would be that it probably hasn't been made, and I tend to agree with you that I don't understand why. Maybe the best thing we do is just strike lines 169 and 170. Again, I'm not making that motion. I'm just, as I read this, that was a concern that I had. But more specifically, I think in line 167 and line 169, that language needs to be cleared up, because what it says now is that there's no discretion. If you're asked, you have to do it. And I don't think that was the intention.
Yeah, I wonder if we could explore language that's something like
Policy or as.
yeah, in accord, or it could be, again, I think the intent was to indicate who would be doing the approval. So requests for blah, 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 blah shall be approved by, or I mean, I don't know.
We have a question kind of related to some earlier comments from Member Hart.
I guess I'm back at, I don't think any board member should be requesting personally identifiable student data at all. Like, I don't, if it's personally identifiable, it's on a need to know basis, and procedures exist to de-identify data. I can't think of a use case where a board member needs, in order to make board decisions, identifiable data. I just, that to me is just odd. I don't think I would want a board member having my child's personal information, nor do I want any other person's child's identifiable data. I would be in favor of striking that line altogether, but that's just a thought. I'm not making a motion either.
We might have some language that we can consider.
Throw that out here.
Oh, Member Lear, while this is coming up, Member Lear.
And I identified sort of a different problem, but related, that I think sometimes keeps cropping up in policies as opposed to rules. We're using phrases, and I'm not sure if we mean them to be interchangeable, or if we're just not being consistent, or if we're trying to broaden something. Where personally identifiable information is different than internal data. And so I'm trying to process, and yes, I do, but let me just get my thought out so I can feel like I've said what I was thinking. Let me read 169. Requests from board members for internal data is different than personally identifiable information, which is usually associated with students and or FERPA. And so I think there's kind of a blend of a variety of phrases in there, and I'm not, because I agree with you, Molly, there's no reason in the world a board member would need student personally identifiable data. I think a board member might request internal data. How many complaints were filed against so-and-so? What is leadership doing about so-and-so number of complaints? That I would call internal data. So I think we need to get our terms straight.
Yeah, and that,
And consistent.
I think I'm simply saying that because lines 54 through 57 define internal data with that piece in it. And yeah, exactly. So I second that. Why is that in there?
So that word is the result of probably 3 hours of deliberation between. No, it's fine. I'll tell you what we intended to accomplish. We were trying to make a distinction between public ready versus non-public ready data. We consider that historically, the board and staff have considered data that is personally identifiable, de-identified but still student level, or aggregate data that does not have disclosure avoidance applied, meaning it has low end sizes or not masked or whatever. We treat all of those not exactly the same, but for the purpose of this policy, we treat them the same way. All of those types of requests need to either be approved by Erin and me, or they come to the board.
Sorry to interrupt, but that would all be student data, right?
Right. Are you talking like versus employee data
Right,
or?
or board member data, or information that the board member, maybe it comes to the board, but it's maintained by the secretary, the assistant, and or the board leadership. So that's when I think that's why I don't like personally identifiable data, because it is really specific in FERPA to student data.
Student data. I'm just trying to pull up that definition. I can't remember.
I
I
know it-
thought our definition was, oh yeah, it does say. So internal data means personally identifiable student data, de-identified student level data, or aggregate student data.
all about students.
All about the
So
students.
I don't think that what we're fussing about in this rule, nobody wants to really say. It's other, not necessarily student data, but I think it's complaints or information or that rarely has to do with students.
That has the more traditional definition of internal. Yeah.
Yeah.
Again,
I just need
no
better
one
terms.
is married to the term internal. So if the committee feels like that's a confusing term, again, we started with the term non-public data, or not data that is not public ready, but that was a little bit wordy. But ultimately, the intention was this policy is generally intended to protect student data. So obviously, we're super open to feedback on how to accomplish that.
Oh. Yeah, and just because we're just putting everything in the mix, so not moving on, but just adding to it. It would be on line 187 and 188. And I know, I think the request that was made for information, this over-the-shoulder review, is what led to the creation of this policy or this proposed rule. Yes. And so an LEA may conduct an over-the-shoulder review of data in person at the USBE building. Are there any, as you thought about this, what is the process for that? Like, what standards are we using? My concern with the language is, it seems to be, it put us back in the same position that brought us here, which is there's no standard. Like, we already know that LEAs can do that because they just did. But what standard are you going, because it doesn't say shall, which I agree with, but when it comes to may, what rails are there to help navigate when we say yes, when we say no to that request?
Yeah, that's a great question. I'm trying to think how to respond.
Well, I thought about
Because-
how to ask, so take your time.
Yeah, I believe that Erin, Director Bruff and I have a common understanding of what this would look like, and perhaps did not communicate that exactly in the policy. Let me read this language a little bit.
Can I ask, as you're reading, and I can ask the committee as well, because I'm trying to, we want to make sure that we give staff a direction. I know that when this happened, we kind of had a direction, but to Joe's point, it's like, well, we did that. We really didn't need to change anything. One thing that I see right off the bat is when we look at line 187, an LEA may conduct an over-the-shoulder review of data in person at the USBE building. Well, one of the guardrails I'd want to make sure is that it actually affects their LEA, right? I do want to narrow it down and say, yeah, we're happy to help you. In the case of Jordan, they wanted to know if the information was accurate so that they could proceed and make adjustments if needed that would affect their LEA. We probably would have said no if they would have said, I want to come in and see what their stuff, you know what I mean? So I think that's one guardrail that kind of jumps out to me. Like, it has to be relevant to your work. And I don't know if this is all going to be done today, and I hate to postpone, more things, but if that's the direction of the committee, I do wonder if we, again, I hate to say it out loud, but send it to staff again and say, hey, we apologize. Admittedly, we weren't as clear, right? We didn't give you any guardrails. We just said, hey, open this up, let's look at it. And so here we are again in the process, and the committee's looking at it and saying, what are the guardrails, and trying to provide more information to staff to help out. So again, nothing formal, but I do wonder if that's kind of the direction that we want to go, is say, how do we help staff get what we want, instead of just saying, no, try again, anyway, Member Wood.
Well, I think if you look above that it's pretty clear. A data steward shall approve an LEA request for internal data concerning the LEA students. So there is some guardrails there in 179, 180. And then 81, 82, if an LEA requests internal data concerning students outside of the LEA for the purpose of auditing or challenging. Now, I'm not sure why. I guess that would be because it was charter data.
Yes, so that falls outside the data that they were requesting to challenge, fell outside of their own LEA, even though it was geographically within their region. It was not their students.
But it is for the purpose of auditing or challenging the validity of USBE data. So we've got some guardrails in there.
I think I need a consolidation of where we're at. Like, what problem are we trying to solve right now? Because I see the guardrails that we asked for. So remind me, I've just lost track of what issues do we have? First of all, I want to say that this is a fantastic cleanup of this. Obviously, we needed to clean this up. There's, a lot of, I actually had pulled up this rule, whatever this is, policy. And I had a question in my notes to ask today, and I'm going to ask it right now. When do we get presented the data governance plan? Like, is that done yearly? Like, there's a report. It's supposed to be reported to the board. When do we do that?
Do you have a line number?
I'll find it.
Okay.
I'll find it.
This is the data governance plan.
Okay.
This policy serves as the data governance plan.
Okay.
And as drafted, the language until now has been that it will be reviewed annually. Our feeling was that was appropriate. Staff's feeling was that was an appropriate standard in the early phases of of the data governance program, and that an annual review is probably no longer necessary.
Oh, okay.
But of course, we're happy to change that.
So that's what I think. I had seen the annual review. So you're taking out the annual
We're striking that language.
because the policy pretty much stands on its own. Do you wonder if we had to make this many changes to clean it up, if we would want to keep an annual review, or at least a 5-year review or something?
My understanding is that because this, and again, I'll mention this policy is the data governance plan. So I understood that this policy would be subject to, is it 5-year review in the same way that rules are, or no?
Do we incorporate it by reference into unless it's incorporated by reference into a rule, there is no automatic 5-year review. But that's not a bad idea to do that with board policies. We just don't have that as a requirement right now. And just for information, board policies, that was a new tool that started in about 2016 for the very first time. We didn't used to have board policies. We just had internal, like staff policies and the rules. But I think that obviously it's become a very popular tool. We use it quite a bit, but we never thought through kind of a regular routine or 5 years. So that could be something we put. It would likely fit in, there's a board policy on board policies. I think it's 1001 or something like that. We could put that expectation in that policy because it makes sense.
I'm concerned that if we don't have a scheduled time for that to be reviewed, that we get behind and not proactive in how we handle data. And we don't necessarily think about it until something happens that is an issue. So that's one thing. But I'm still back on what problem are we trying to solve right now if we were to send it back, because I've lost track of our issue with it. Can someone tell me? Because it does have the guardrails for the situation that we had run into. So what issue have we found since that we're concerned about?
Yeah, to Vice Chair Hart, in addition to the use of the word shall approve, I mean, there's a ton of those. Even here, it says a data steward shall approve an LEA request. And again, I understand I understand the intention. I don't believe that's what's reflected. But then even with the specifics, we're like an LEA may conduct an over-the-shoulder review of data in person at the USBE building. Well, when Jordan came in here, I shouldn't say work, I stayed in touch with Scott Jones to make sure that I knew what data was being provided. I didn't want reams of our data flowing outside this building to Jordan or any other LEA. And that didn't happen. But again, we don't really specify what that means, right? It just says, well, yeah, they can review the data. Does that mean they're getting something? Are they receiving something? It's not defined. The other thing is here, it says the director of, this is line 183, the director of data and statistics and the director of privacy shall approve the request. Again, that easily changeable. But I do have a question on this. It says in line 185, the director of data and statistics and the director of privacy may bring a data validity request to the Law and Licensing Committee and board for approval. Are those two lines referring to line 182, where it says challenging the validity of USBE data? That's what I thought. Yep, but I just have one question. But it says that you could bring a data validity request, but it doesn't say, what if it's not a validity challenge? What if it's for the purpose of auditing? Because in 182, you give two reasons why this measure could be triggered. But in 185 and 186, you're limiting your ability to bring something to Law and Licensing and the full board to just the data validity request. Does that make sense? And I wanted to know, why wouldn't you want that same option for purposes of auditing?
That was an oversight. That's a good catch that I had not caught. The intention here, 85 to 86, and full disclosure, this was something I wanted, was that if Director Bruff and I are on the fence, that we could build in an opportunity for us to bring something to the board. But it was not intended to be limited to only those that are dated. Oh, actually, well, I think this is residual to an earlier draft that we were working on. So it probably should say, may bring a request for the purpose of auditing or challenging the validity of USBE data to the Law and License, to add that language that you're talking about.
You would want both there, both pathways.
Yes, that was the intention.
Thank you.
Can I jump in? I think this is actually really helpful. And I think when we look at board policy, it's important to dive deep into this. So I don't want to cut this short. And at the same time, I want to recognize the agenda items that we have. And so I want to make I want to just kind of talk to the committee. Most likely we're going to postpone something. We can continue on with this discussion. I'm happy to do it. I don't know. And I guess I could ask Angie where these fall on time sensitivity, right? So I'm just trying to get a feel for where we are as we have just over 30 minutes left. And I want to continue this conversation because I think that board policies are important. Just so to remind the committee, the upcoming agenda items are board policy 2006, which again, we want to take time on. Board policy, we want to make sure it's done right. Well, with every policy, quite frankly. And then board bylaws, Article 9, and then personnel management audit report review. So that's what's on the agenda for the, including this board policy 3006 that we're currently in. Angie, please.
So I think to answer your question, board policy 3006 is not urgent. I mean, we're not amending it because of a law that passed, for example. So you could, especially because of this feedback here that we've received, I think will help inform a better draft after this. 1.8 and 1.9 were both being amended related to the passage of a bill from this last session. I think it's SB 244. It was related to new auditing requirements. And both of these two documents, there's at least been background discussion in the audit committee. I'm not sure if the drafts were presented to the audit committee, but the reasons they are being brought forward in part are due to law changes. And then the last one is an audit report that probably could be deferred another month if needed. So that would be if I were prioritizing, I would say 1.8, 1.9 would be the first two, then to come back to and the other two could potentially be postponed.
When you say the other two, you're including the one we're in right now,
The one
3006.
Yeah.
But you feel like 2006 and the Article 9, the board bylaws are more time sensitive.
They're more time sensitive
to
than the
law
other
that
two, because of the passage of a bill from this last session. Would you agree, Debbie? Ish?
Yeah, they're mostly for clarification.
Okay.
So
Okay.
if they had to wait a month, it would be.
Oh, okay. So that's not
Okay,
that
so
the legal
nothing's really
requirements. Yeah.
like forced here. So
No.
let me just take an informal poll of the committee. Would you like to continue on with this? Are we in a zone that I've already broken on 3006, or would you prefer that we postpone this and move to agenda items 1.8 or 1.9? Is there any thought, Vice Chair Carey?
Yeah, I generally support the direction of this proposed policy update. But again, I'm concerned that we don't get it. We're not specific enough, not specific with 187 and 188. I would like to see guardrails or just, it also would help the LEA to know when they come in for an over-the-shoulder review, what do they get besides literally standing over the shoulder of Scott Jones as he's going through data, if anything? That's what I would like. And then I think the rest, it does need more time just to fix the shalls and mays, because I've noticed now that's all over this, not just the two original instances that we had discussed.
Just a question to that. Is this something that in your mind, do you feel like we would move forward to the full board and allow the month to be addressed? Or is it something that we would like to see in committee again? And I see, we'll go Vice Chair Carey, then Member Lear.
Yeah, I'd prefer to see it again before we pass it on. I think we've had an instance earlier with 123 where we think there's something in place and it looks good, but then when you get another pair of eyes on it, you look at it and say, oh, there's a lot of changes that need to happen here. I would rather have it come back and let us look at it again, especially since it does not appear to be time sensitive. That would be my preference.
Thank you. Member Lear?
I agree. I'm troubled. I need a better understanding of the kind of data we're talking about, clear definitions. Because like I said before, I rarely think, although the Jordan example is a good one, but I rarely think that the PII is the issue. I think it's more often other kind of data, and I'd like a clear delineation between those. And I think that's going to take time. It's throughout the rule. I caught it.
Thank you, Member Lear. Let me ask staff, do you have, I'm gonna ask if you have questions, what we can answer as a committee as you prepare to bring this back to committee, which is an informal thing as of now. But what questions do you have that we can help you prepare this so that we can have further discussion?
Thanks, Chair. I appreciate that. I wonder if I could read back to the committee the notes I've taken on what might be changes. Just I don't have any outstanding questions except that I just want to make sure this is comprehensive. All right. So first change, bringing this to for an annual review. I think I understood that from Member Hart seeking that. Clarifying the shalls to indicate that we're not obligated to share, but we are indicating the party that does the approving, not the necessity of approving. Clarifying what an over-the-shoulder looks like and adding some guardrails there. Limiting the data validity review to data which affects the requesting LEA. I think I heard that from you, Chair Hymas.
And to Leanne's point, that might be in there, right? If I'll ask that you look at that and make sure it's clear. I just missed the lines. You know, we're chopping this thing to pieces. I get, so thank you.
Okay. On line 186, specifying that a data validity request includes the broader purpose for the purpose of auditing or challenging the validity of USBE data. And finally, some clear definitions of the type of data, for example, indicating the difference between student data versus educator or other data, from Member Lear. That's the extent of my notes. If I missed anything, let me know.
Committee, do you feel like she's captured our thoughts and deepest desires for this policy? Member
One
Lear?
more, and this is sort of part of, I think one of them is, I just think it's important to look realistically about who's going to approve these. You guys make tons of sense, I think, in the Jordan situation, for instance. But you don't necessarily make as much sense if this rule or this policy addresses a board member seeking information from about other board members about complaints that have been received. What, in my mind, is kind of your broader internal data category. So I just look carefully at who's and this is something that I hope you'll work with the policy people, the additional policy people at the board, because I don't want to be, as a board member, personally speaking, I don't want to be approving every request for internal data that might come from a board member. But I think we can just we should be able to set up a standard. And so just get some assistance from them about what overloads the board, what's appropriate for the board, what's appropriate as data policy experts, data governance policy experts.
Thank you, Member Lear. Vice Chair Carey.
Yeah.
And then Member Wood, is that right?
With line 185, my thought is similar, which is it says that you may bring a data validity request to the Law and Licensing Committee and Board for approval. I don't know what that gives us. Like, I think you could do that now. And so I read that and I'm like, well, it seems like there's something you're thinking of that is not here. So I would just say, like, let's get that on paper, because right now, then again, I'm left thinking, what does that language mean? Like, what are they thinking? What are you looking to bring here that you otherwise would not? And if there's any directionality on that, that would be helpful.
Yeah, should I respond to that now? So our understanding from the committee's request 2 months ago is to create a process for those types of requests, the kind of requests we got from Jordan School District, that sort of removes this committee from being involved. That was how I understood the request. I personally did not want to put myself in a position where I always have to make that decision. So I wanted to write in a little ability for Aaron and I to bring some, if it seems especially sticky, that we could bring it back to the committee. Although the intention, as I understood it, for lines 181 and 182 was to generally take the committee out of that kind of request. I don't know if that's clarifying.
No, it does. And like I said, I knew you were thinking of something, and I don't know if sticky is statutorily appropriate to put into a rule, but if you could just capture as best you can when you see that happening, like what would make something so out of routine that you're like, you know what, I should consider the right.
Yeah, thank you. I think, and remember, Wood, I haven't forgotten you. I think that's what we're trying to do here is say, you know, with our LEAs, it is difficult. We want to be supportive. When we talked about the Jordan School District, sometimes it's a process, right? It's at least what, 2 months, you know, month and a few weeks, but no. Anyway, Member Wood, go ahead. Sorry.
Well, this is on to another topic, if that's appropriate. Since we're going to dig back in here, I might add my request to look at when people come asking for our data for research purposes, that we could add a portion into our data governance policy that really looks at, we kind of have a check the box. Does this help our students? Does this help move forward our strategic plan? If we're just handing out data just because, does it really fall in with where we want to be?
Chair, can I ask a clarifying question? So, Member Wood, are you seeking for staff to, so my understanding is that the goal ultimately would be myself and Aaron would use this new language that we bring to you to sort of filter the requests that we receive. So basically, if someone comes to us with a request that does not meet the thresholds of helping Utah students moving forward the board's strategic plan, that we would decide, we're not even going to take that to the committee. Is that the intention? Or is it more to guide you in your decision making when we bring it to the committee?
I know it's a really good thought, because if it isn't, if you've established a threshold that the board has approved at the end, would we even have to see those? Like, it would really ease some of that burden, and especially letters that we get, like stop handing out my children's data, right? And then that's where I think we've gone so far, is we don't have even any decision-making tools as to why we do this. And so I guess that would be really up to the board to determine when it comes back to the board. But I think there's value to research, absolutely. But does that value always come back to the Utah public education system, or is it to some entity who wants to just use our data for the work they are doing? And does that matter? Maybe for some it does not. Research is for research purposes, and it doesn't matter. To me, I think we need to be in this world where people are very concerned about where their children's data is going. We need to be more thoughtful in our process of when we share.
Chair, so perhaps we could draft something that says, kind of similar to what we were talking about earlier. So Aaron and I use that threshold. Does it help Utah students and or move forward the board's strategic plan? If not, we don't bring it to the committee, we just decline it. Or if we have questions about whether, if Aaron and I are not, totally sure that it does help Utah students or move forward the strategic plan or not, then we can bring it to the committee. I mean, I can put together some language. I just wanted to start to understand what you're looking for. Okay.
Follow-up question, if I may, too. when you say research and looking at this realm, there are a lot of requests for information that's just kind of hard to find, if that makes sense, where it's not necessary, it's not currently on our website, for example, or they might be asking for a series of information. It's an aggregate that we would call publicly safe to share. It's just not readily available. But as we review, we would say, this really doesn't enhance the board's purpose. So this is the follow-up question. So in those situations, and there's a lot, and that's, I can't just say, here, put my finger on 2 or 3 of them. Are you saying those we should be more likely to decline because it really doesn't line with what the board is trying to do? Meaning, do we narrow this or put a filter on it saying general requests that come in for whatever the research purpose may be? Because there's a lot of students, for example, working on their master's, their PhD, and they've got an idea and they reach out, to multiple states or whatever. And we hear these ideas and sometimes like, okay, that's not where I would say the board is trying to go, or, general benefit of the students. It's more of what the individual researcher or, master student or whatever. I'm just throwing the question is, are you saying those should be filtered as well to this checklist, or do we kind of still keep that kind of open? I just, that's a follow-up question, is trying to gauge what you're thinking.
Well, and I think that's part of the policy, right? I think that's the ultimate decision that the board makes, not myself and my opinion or you two. I think that's the ultimate decision of the board. Where do we want in this world where data is the new, what is it? The new currency. Thank you. I'm like monetary something. What's that word I'm looking for? Where data is the new currency. What is our philosophy as a board? And that's where I'd love to see that. Do we just, if it's already publicly available, it's public shared data as your definition in this, does that, should that matter? Probably not, but that's me, right? It's not my role. It is, I'm a part of a board that comes up with, where our philosophy is. So I'd like to add that in there, since it was something that I've been talking about as we've been talking about our strategic plan and data governance. I'd love to see us have a plan. So is that helpful?
Yes.
Okay, thank you.
We are talking about, when we talked about adjusting this policy, we're not talking about outside organizations or researchers. Yeah, you want that to not come before the committee. Is that what I'm hearing? Okay.
Just to be part of, as
I
we're
know I
as we're
missed
building, as we're sending it back, I'd like that to be incorporated that in there.
Okay.
Like, let's talk about this now.
Right. You just want it spelled out. This is going to be a long policy, isn't it?
Well, it is data.
No, it's important. We want to make sure we get it right. That's why we're glad that you guys are asking questions. Angie, go ahead.
When we start moving into requirements related to outside entities, we'll want to think about, because we do have a rule on data, and that would more govern like LEAs and their use of data. I'm not saying what you're requesting doesn't fit in this policy, but there might be some things that need to be in the board rule instead of the board policy if it starts to restrict or direct people outside. Right now, although the board policy does impact people outside because it's really describing the process that we use internally, the primary goal of the board policy 2000 or 3006, I forget which one we're on, is to bind staff and how they are managing the process in our data governance plan. Anything that's supposed to bind or direct LEAs or members of the public would go in the board rule. So it might be that you might need to bring them both back.
Well, and just to follow up, this is where I'm binding staff and the board in terms of outside requests to us, not just LEA requests, but we get lots of requests from universities. And is there a difference between helping out a USU or a U of U or a BYU versus a Virginia State? Like, is there a difference? Like, one is incorporated in our state. Maybe we are looking at the state public education system. So it is really about binding the staff and us in terms of how we share out.
Yeah. Member Lear.
I almost changed my mind, but let me just add, if you look at that for the purposes of this policy, I hope you give us some options, because I maybe am thinking a little more expansively than Leanne. And yes, I would like to give preference or priority to those requests that could benefit the board, but not only those that are specific to the strategic plan. And I also feel strongly about we are a public entity that, yes, has sensitive data, but we, in some cases, are the only reasonable source of that sensitive data. So I don't want to be completely unsympathetic to researchers who can't get information unless they go to 160 plus LEAs. So I just give us some open-ended or a couple of options in doing that. So and that's the idea, that's the difficulty and the beauty of working with the board. There'll be multiple opinions.
Yeah, before we make this a formal motion to send this back to you, is there anything in your notes that is conflicting, as we each have different thoughts and things we'd like to see? Is there anything in there? I don't want you to come back next week and, well, we told you this, or next month. And is there anything in there that's conflicting where you're like, look, I don't know how this is going to work together? Just, I know it's brief, but there may be. Well, and there may be. That's what I'm saying. If there's something that stands out, like, I asked for something and then Leanne asked for something, and you guys in your mind are like, that's not going to work, but we're staff and we're going to type it. And, is there something that sticks out to you on your computer screen that says this could be an issue?
I don't see aside from the last point that was made about, different board member opinions. I don't see conflict. I do expect Aaron and I will have a rigorous discussion about how to, but it's not because of anything the committee said. We'll just have to hammer it out. But we can bring something to you.
Thank you. Any other comments on 3006? Here's what I'd like to do. I don't know, for the information item, how long are we looking at that one? Debbie, can I just call you out and say, how long are we looking for item 1.10?
I don't think we should even touch it.
Okay. That's what I'm asking. So, we don't have sufficient time to go through the other ones. So Angie, I don't know if we need to just adjourn and these just magically go somewhere, or if we need to put them somewhere. Yeah.
Yeah, you can adjourn and then those would just automatically go over. Do you want to make a motion on this one, or just?
Yeah, we'll make a
adjourn?
formal motion on this one. I'm just letting the committee know we have 10 minutes, so we can either be done 10 minutes early, or we can talk more on 3006. I think we've talked a lot. I think we've given a lot to staff. Is there anything else that on 3006 that we want to bring up here? Okay. With that, then I'll make this motion.
Okay.
I move that the committee postpone discussion of board policy 3006 and ask staff to bring an updated draft of the board policy back to a future committee meeting. Any discussion to that motion? Seeing none, all in favor say aye. Aye, that passes unanimously. With that, if it is okay with the committee, I would move to adjourn. All in favor? Aye, we're adjourned. Thank you. Thank you, staff.